Hello again. My name is Thomasina Thornton, and I am a licensed New York and New Jersey trust and estates attorney. Welcome to this segment of Estate Planning Essentials. Today's topic will be power of attorney documents. This is part one of 6 parts. The reason that I'm breaking it down is because power of attorney documents are vital to a good estate plan. In addition, over the next 6 parts, I'd like to cover issues like, what is a power of attorney? I want you to understand what the concepts are, what the components are, what the different types of power of attorneys are, what are the advantages of having a power of attorney, and what are the repercussions of not, how to go about choosing an agent, things of that sort. Now, let me give my disclaimer. By no means am I trying to give you specific legal advice. Each person's situation is going to be different. In addition, most states have their own specific statutory provisions that should be incorporated in a power of attorney. However, the concepts of power of attorneys are pretty general from state to state. Now, if you live in the states of New York or New Jersey and you have any questions, feel free to give me a call. I would love to talk to you. But if you live outside of those states and you have specific questions, then I would suggest that you seek counsel in the state in which you reside. Now, with that said, let's get started. So, what is a power of attorney? A power of attorney is a written legal document that allows you to appoint a person or persons to make legal and financial decisions on your behalf. Now, allow me, if you will, to give you a visual. Close your eyes for a second and picture a wrestling match. In that wrestling match, you are one of the wrestlers. And with most wrestling matches, you have a backup person. So, you see yourself in the ring, and you're fighting, and things start to go badly. You start taking a blow. And what do? You call in your partner. Your partner is waiting in the wings to come in and assist you. Your partner gets in the ring and he starts fighting on your behalf. Perhaps you start to feel better and you want to jump back in the ring. You can tag your partner out and you tag back in and continue the fight. Or perhaps you realize this is a little bit more than I can handle and I want my partner to finish out the match for me. In essence, this is what a power of attorney looks like. Now let's look at it from a legal standpoint. In the document, often you'll see certain terminology. The first terminology that I want to talk about is the principal. You are the principal. The principal is the person who makes the appointment. He or she will then appoint what's called an agent or an attorney in fact. This is the person who makes the legal and financial decisions on behalf of the principal. The agent can act in one of 2 ways, either temporarily or permanently. Temporarily would be an instance where, let's say, the principal had an accident or was hospitalized for an extended period of time and needed help with his or her affairs while he was out of commission. Once they're back on their feet, they jump back in and handle their own affairs. However, some people need their agent to act on a more permanent basis. For example, those who may suffer with a degenerative disease, such as Alzheimer's or dementia, they may need their agent to act upon their behalf until their demise. There are also different types of power of attorneys. The first that I'd like to discuss is a durable power. A durable power of attorney takes effect immediately, regardless of whether the principal is incapacitated or disabled or just unavailable. Now, this doesn't mean that the principal can no longer act upon his or her own behalf. It simply means that both the agent and the principal are empowered to act upon the principal's assets. The other type of power that we sometimes use is what is sometimes referred to as a springing power. That springing power creates the ability for the agent to only act if the principal is physically or mentally incapacitated. Some power of attorneys create what's called broad powers, which means that the agent has full control and access to the principal's assets. On the other hand, some powers are considered limited powers, which means that the agent is restricted in regards to acting upon some of the assets. meaning maybe only having access to some of the bank accounts or to only certain pieces of property or only for a certain period of time, whereby the power of attorney would expire and it would be up to the principal to renew that power of attorney. Most power of attorneys are revocable, which means that the principal has the right to revoke it at any given time. And that's as easy as taking the document and tearing it up. However, the principal will have the responsibility of notifying the financial institutions that have copies of that power of attorney that that power of attorney has now been revoked. On occasion, we'll also find that a principal may have created an irrevocable power of attorney. That means that the principal is no longer allowed to make changes to the power of attorney or to revoke it. This brings us to the end of part 1. I'm hoping that you will join me for part 2, where I will be answering the question, who really needs a power of attorney? My name is Thomasina Thornton. I'm a trust and estates attorney. If you have any questions, please feel free to give me a call or send me an email. I hope that this video has been helpful to you. I thank you so much for watching. And as always, my wish for you is that you be well and you live long. I will see you next time. Bye-bye.